what is illegal discrimination? It's where an employer treats an employee or an applicant differently. So already we know we have two populations, employees and applicants. We've got to make sure that we don't forget about the applicants in all of the things that we deal with, okay? And we're treating them differently in any aspect of employment. We'll talk about that in just a minute. And we're treating them differently based on their membership in one of the protected groups, okay? After the original bill was passed, the courts have interpreted, it's been through the courts many times now, and the courts have interpreted that to say that illegal discrimination also includes harassment and retaliation. So we're going to talk about all of those things. All right, so first of all, who are the protected groups? So we already talked about race, color of your skin, national origin. We talked about religion, and we talked about sex. We're going to come back to that in just a minute. Since then, there have been other laws that have added other things that are protected, such as pregnancy, age, disability, genetic discrimination, and sexual orientation and gender identity. Now, genetic discrimination is a law. I'm not sure if it's in your textbook yet because it's so new. It's only a couple of years old. It's so new that we don't have a lot of court interpretation about it. So I'm not going to talk about genetic discrimination much at all. The idea behind genetic discrimination, an employer cannot discriminate against an employee or an applicant based on their genetic makeup or their genetic history. The place where some employers are getting in trouble is in the genetic history part, where they are doing pre-employment medical examinations, and they are asking the applicant to write down their medical history, which might include some information that would disclose a family history of something that might be genetically related. Okay? That's all I'm going to say about that. Any questions about it? Good, because I couldn't answer them. Okay? Sexual orientation, again, I'm just going to talk briefly about this one because this one is it's not protected by any federal statutes. It is covered, it is protected in some states, but ARUP and the University of Utah are required to comply with this because it is required in many cities. In fact, Salt Lake City is one of those cities, and there are more than 20 cities in Utah that have adopted this as part of their legal requirements if you're going to do business in their city limits. So this is a developing thing, as you might know. I've been watching it for 30 years now, and I've watched it go from not even on the radar to right in the heat of the radar, and it's going to be fun to see what happens with sexual orientation and gender identity protection coming up in the next few years. I think that there's going to be a federal law coming up quite soon on that. So, all right. So we've got our 5 protected groups here. So the other part was we're going to treat them differently in any aspect of employment. So this is the whole life cycle of an employee, from applying for a job, advertising for jobs, through the interview process. You need to make sure that people who can't hear are able to go through your question and answer period in your interview process. Hiring them, transferring them from place to place, how do you move within this company, both physically and career-wise. Promotions, compensation. Are men paid more than women? Women make, 70 cents on the dollar for what men make for the same job? Okay, that's not right. Job training opportunities and termination process. So it's the whole life cycle. And then they add in, I always love these, they add in things like any other term or condition of employment. Okay? So this is the attorney's full employment clause that they throw into laws to make sure that the attorneys can take these things to court and debate them and make money. Okay? All right. All right. So what does it mean to treat an applicant or an employee differently? And the courts have interpreted this. And they've come up with three plus one definitions of discrimination. The first one is disparate treatment. Disparate treatment is the kind of discrimination that you were thinking of when you started reading about employment law. You knew about discrimination, and you knew that that was where employers won't hire women because they don't think women are good enough to work there. They won't hire Asians because they're not smart enough to work there. I'm filling in the blank here, okay? It's the blatant kind of discrimination that you were thinking of. Hiring only men to be firefighters, not hiring pregnant women. These things have all gone through the courts and gone all the way through the Supreme Court, and indeed the courts have recognized that disparate treatment is illegal. Any questions on that one? Sure.
So, like when things are kind of practical, so say like you have a fire station and they've got like a full crew and it's only guys, and they get 2 applicants for a job. One of them is a guy, one of them is a girl, and they just find the other one to be the guy to be like a better firefighter. Like how's like I can see where like maybe they would get sued because of like they're not hiring women, but they just were hiring the person they thought was best. How does that work?
Okay. Let me tell you about the case that went to the Supreme Court. Similar sort of thing. And the fire station hired the guy because guys are firefighters. I mean, how can you be a fireman if you're a woman? Right? Because it's a fireman. Right? It's a mailman. Okay? Right. So, and traditionally, we've just hired, why would we hire a woman? So what the courts, as it went through the courts, what the Supreme Court came back with was to predict who's going to be a good firefighter, you can't use sex as a predictor, because really what you want is a person who can put on 75 pounds worth of fire protective gear, run a 30-yard dash in under so many seconds, carrying 100 pounds of rolled up hose, climb a 30-foot ladder, spray a hose with nozzle velocity of whatever it is, then climb through the window wearing this protective gear and the oxygen suit or the oxygen tank, climb through the small window, find the 120, 140 pound dead weight that's in there, pick it up, put it over their shoulder, climb back out through the window and take that down to the bottom successfully without killing themselves or the dead weight dummy that you've put up there for them to go get. So if you apply for a job as a firefighter today, that's what you'll do. It's not, and the reality is that when you do that, more men than women will be selected, but women will be selected too. So that's how that kind of came out. But it's a good illustration of kind of what you were thinking about. Okay? Let's talk about this one. Disparate impact. This is one that you haven't thought about because this is unintentional discrimination. This is a discrimination that happens, you have a policy in place that has the effect of discriminating against certain groups, okay? So laying off highly compensated employees. Weight limits on flight attendants. Oh, I like this one. So laying off highly compensated employees, who's highly compensated? So it's a practical question. I have to do a layoff. I need to cut down my salaries. I can either lay off 10 highly compensated people or 20 rank and file people. And I don't want to, I want to keep this down to a minimum. I don't want to lay anybody off. But if I have to lay people off, let's make it the smallest number possible. So let's lay off highly compensated people. Problem there is that people who have been in the workplace for a long time are the ones who are usually more highly compensated. And so age is the time bomb, the ticking time bomb that you're going to run into. Weight limits for flight attendants. I love this one. This was in the 1980s. In the 1980s, there was an oil embargo, and gasoline prices went out the roof. They literally went from like 75 cents a gallon up to $1.50. Thank you for laughing. Yeah. Weight limits for flight attendants. So the airline was only hiring women. Again, there are jockeys who could make this weight limit, but they were only hiring women, and they were only hiring women who were less than, I think, 120 pounds. So they weren't even hiring women that are of a normal weight. They were hiring underweight women. And if the woman gained weight, they would fire her. Okay? So it goes all the way up to the Supreme Court, and the airline's defense. What was the airline's defense? Anybody want to take a guess? It's the cost of gas. That's right. At 120 pounds, that flight is going to make it to Detroit. At 121 pounds, it's going to fall short and land in the Lake Michigan. Yep, that's right. That's right. Okay. Requiring men to be clean shaven. What's that a problem for? Sorry?
Probably some religions.
Religions, yeah. Religious discrimination, yep. Same thing with hats. Here's one that's not on the list. Okay, let's say you're an employer and you want to do background checks. You only want to hire people who are, good, upstanding citizens. And you come up with a policy that says, we're not going to hire anyone who has an arrest record. What's the problem with that? Who would that discriminate against? Okay.
Criminals.
You can discriminate against criminals. Are these people criminals?
Well,
Not necessarily. Why not? They haven't been convicted. Okay? And then let's add that to something else that you know, but you're not thinking about right now. Who gets arrested more often than white males do? Actually, who gets arrested more than white females do? Minorities. Fill in the blank minorities. Mostly blacks, but other minorities also get arrested at a much higher rate. They're not necessarily convicted, but they're arrested at a much higher rate. So that's the disparate impact you would have. Okay? All right. The next one that the courts determined was harassment. Now this, we have to go back to that bill that got amended twice, and it got amended with a poison pill that didn't work, and it was sex. Okay? Harassment. Sexual harassment was the very first toe in the water for harassment discrimination. Okay? All right. And it's the kind of harassment, sexual harassment, that you're thinking of. It was the first one that went through the courts, which was quid pro quo sexual harassment. Quid pro quo, meaning if you give me this, I will give you that. If you will have sex with me, I will get you the promotion you want. I will get you a job. I won't fire you for violating the rule I just caught you violating. Okay? Quid pro quo. Sexual blackmail. Okay? In order to have quid pro quo sexual harassment, you have to have someone in authority and someone under their authority. Okay? It doesn't work for coworkers. Okay? Coworkers, if you won't have sex with me, what am I going to do? What kind of blackmail can I do? There's no blackmail there. So quid pro quo. So the hostile work environment is where the courts determined that there was a case for coworkers. And the case that came to the Supreme Court on this one was a female welder who got a job back east in one of the shipbuilding yards. She was the first female to ever be employed in the 200-year history of this shipbuilding company. And imagine the team of guys that she got put with to build these ships. They didn't want to be the guys who had to work with her. Okay? So imagine what kind of world they created for her. I mean, it was probably already pretty sexually inhospitable. They probably already had the pictures hanging up in their lockers. They probably already had the crude language, but they really turned it on when she worked there. And they really made her work life a living hell, to the point where she couldn't get her work done. She complained to management. They did nothing. Their response was, "What did you expect when you applied for this job? We hired you, so we didn't discriminate against you." So she took this to court, went through all the courts, went up to the Supreme Court, and the Supreme Court said, indeed, if coworkers are creating a work environment that is so inhospitable, that's so hostile, based on a person's sex, was the first one that went through, then indeed it can be an actionable item and the person can file a lawsuit, and the employer is responsible for making sure that these work environments don't exist. So they started out with sexual harassment, and then they brought another one about religion, and the Supreme Court finally came out in one of their opinions and said, all right, don't send any more of these to us. It applies to all protected groups, the idea of harassment. Okay? Quid pro quo really is only related to sex. I can't imagine how you would do any kind of blackmail with any of the other protected categories. If you don't get old with me, I don't know how that's going to work. If you don't convert to my religion, I don't know. Okay. All right, so I told you that there were 3 plus 1. And the plus 1 is retaliation, is a form of discrimination. So this is where you retaliate against someone, trying to prevent them from filing a lawsuit, or trying to intimidate them into dropping their lawsuit if it's already been filed, or intimidating someone who has been called as a witness, or anything like that. Okay? The courts and the Congress don't take kindly to people trying to blackmail or bully people into circumventing these laws that they put up. So they put in this retaliation clause. So let's talk about, so retaliation is a tough one. What is retaliation? Retaliation is very subtle. I had an attorney tell me once, retaliation sounds like this. So what's your name?
Erin.
Erin? Erin comes to me, I'm her supervisor, and Erin is so excited today because she just found out that she's pregnant. And my response is, oh no, you're going to be the 4th person who's going to be out on FMLA, and how are we going to get the work done? There's not going to be anyone here. You're abandoning us. What, do you not care about patient care? Okay, so yeah, all of those things are true. I'm just worried about patient care. And she hears that and she remembers it, because then 4 months later, 5 months later, it turns out that Erin's work performance is actually slipping. And I need to talk to Erin about her work performance that's not up to par. Her quality has fallen, her productivity has fallen, and I bring her in and I talk to her. And the whole time I'm talking to her, she doesn't hear a word I'm saying, because what she's thinking is, he's mad at me because I'm pregnant and he's trying to get rid of me. He's retaliating against me because I'm pregnant. Okay? It's that subtle. We've got some examples up here that you can read, but it's something that you really have to actively watch yourself on as a manager. Okay? Any questions on that? What was the number one thing that the EEOC, the number one cases, the number of cases in their caseload of $1 million a day, 100,000 cases a year? Retaliation. Okay, very good. You remembered.